Will the U.S. government support Ripple in court? Will the SEC be able to resist Ripple's argument? How much will the XRP court field cost? We will answer these questions in today's video. The U.S. Securities and Exchange Commission, SEC, lawsuit against Ripple Labs is not the only battle the company is currently fighting. In fact, there's a court case that has been under trial for a longer period of time. The class action lawsuit filed by XRP investors against Ripple Labs and CEO Brad Garlinghouse, which has been pending since November 2018. The case, which is being heard in the U.S. state of California, is led by lead plaintiff Bradley Sostak, with 3 lawsuits, Zakinov, O'Connor, and Greenwald. Consolidated into one, the plaintiffs accuse Ripple of selling XRP as an unregistered security and seek damages for losses suffered from the sale and alleged promises by Ripple. In addition, the plaintiffs are asking the court to also classify XRP as a security. Attorney John E. Deaton, who is already involved with a respective amicus brief in the Ripple vs. SEC and LBRY vs. SEC and LBRY vs. SEC cases, is now getting involved in this case as well. As prominent criminal defense attorney James Filan writes in a series of tweets, Deaton is filing an amicus brief in Zakinov vs. Ripple. Filan writes that the proposed class would include XRP holders around the world, including the 75,890 holders in the SEC case who have joined Ripple's arguments and disagree with the plaintiffs in Zakinov, saying that XRP is not a security. Moreover, the proposed class action is not limited to direct sales by Ripple, but extends to all sales of XRP, including secondary sales and international sales in countries where the token has already been classified as not a security. Deaton argues in his motion that the court should not certify the class because of these conflicts and because there are only a small number of holders who claim that XRP is an unregistered security, while vastly more token holders worldwide claim that it is not. Just added to our document library. Order granting E. John Deaton own admission pro Hake, vice representing XRP holders in U.S. District Court for Northern District of K, in Ripple Labs ins litigation. Link to order. Fred Rispoli, also an attorney from the community, commented on Deaton's move with applause, saying, being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls top. Plaintiff's counsel. And I don't disagree with John, but the ball kick cannot be overstated. For his part, Deaton commented on Filan's announcement on Twitter, saying, whether it's the SEC or a plaintiff's attorney making the absurd argument that secondary market transactions of a token are also securities, simply it may have been previously offered or sold in a way that violated Section 5 of the Securities Act, I'll see you in court. Attorney Deaton scored a huge victory for LBC token holders in the whole cryptocurrency sector at yesterday's hearing between LBRY and the SECs in the Warren B. SECs in the Warren B. Rudman United States Courthouse in New Hampshire. Deaton, who represented tech journalist Naomi Brockwell as amici curiae, persuaded the judge that LBC secondary market transactions do not constitute a security. Remember that the SEC tried to sidestep helping LBC by asking for an injunction that applies equally to LBRY, the company's management, and the public? Because of the injunction's wide scope, Brockwell and other LBRY users' attorney Deaton is attempting to have it clarified so that they may engage in secondary market transactions using LBC. According to Crypto Law's creator, he relied on an essay by commercial contract attorney Lewis Cohen that provided a comprehensive overview of all security matters heard in the United States after Howitt. According to Deaton, no U.S. court acknowledged the underlying asset was a security at any point in Cohen's review of security cases. In court, Deaton elaborated on his comments to the judge as follows. The article argues that your ruling seems like you may be suggesting that LBC is security in itself. Please explain yourself. Judge, if you don't mean that. After some back. And fourth, Deaton said the judge stated his disinclination to issue an injunction. He elaborated on the significance of the judge's comments, saying that it was a huge victory since it meant that LBRY users would not be subject to an injunction. Notably, Deaton stated that he had the SEC officially state on the record that secondary market transactions using LBC do not constitute a security. The crypto community applauds the LBRI hearing, which highlights the high stakes at play for every crypto asset Deaton. Deaton's work in the LBRI case, which might be applied in other crypto-related matters such as Ripple v. SEC, has garnered praise from a number of crypto aficionados. Jeremy Hogan, a partner at the legal firm Hogan, praised Deaton on Twitter today for getting the SEC to officially acknowledge that LBC as a token is not a security. The first statement from the LBRI hearing with the SEC. The SEC has said publicly that tokens themselves do not qualify as securities. Mr. Deaton, you've done a great job. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one advocates for the Bitcoin business-like crypto law's creator. The SEC of attorneys involved in the LBRI lawsuit have admitted over the record, that WholeBC tokens sold on the secondary market are not securities. Second, nobody advocates more vigorously for the crypto community than Erjana Deaton. If it weren't for him, the SEC would have it so easy. Ripple's general counsel Stuart Alderoty has reacted to a recent Bloomberg article titled, "Fight to Regulate Crypto at Crossroads as Ripple Ruling Looms." The article, published yesterday, explains how an upcoming Ripple v. SEC lawsuit ruling will determine which federal agency between the SEC and CFTC should regulate the industry. Bloomberg, in reference to the lawsuit between the SEC and Ripple, said, "An upcoming ruling in New York federal court could help determine the answer, along with the fates of numerous crypto investors and companies. The case hinges on whether a prominent digital token should be treated as a security, which would fall under the Securities Exchange Commission jurisdiction." The leading media outlet cited comments from former SEC's legal representatives, with the majority saying that the implosion of cryptocurrency exchange FEX will determine the outcome of the Ripple lawsuit. Reacting to the article, Alderoty said irrespective of how Bloomberg dissects the lawsuit, the experts all agree that the outcome of the case will affect the future of cryptocurrencies in the United States. No matter how you dissect it, the experts agree. The outcome of the Ripple case will likely have a significant impact on crypto's future in the USE, he said. The ongoing Ripple case has captured much attention from the XRP community and other cryptocurrency investors, thus suggesting the significance of the lawsuit in the U.S. crypto industry. There is an ongoing debate over who should regulate the cryptocurrency industry, with top industry players like Ripple's CEO Brad Garlinghouse backing the CFTC to emerge as the appropriate regulator for crypto. The SEC, under the leadership of Gary Gensler, is trying to position itself as the cop on the beat for the emerging market. Carol Goforth, a professor at the University of Arkansas School of Law specializing in fintech regulation, said in the Bloomberg piece that should the SEC win the lawsuit, the regulator would claim jurisdiction over most crypto assets. However, a win for a Ripple could reduce the SEC's claim over becoming the regulatory watchdog for crypto. It bears mentioning that the SEC has faced criticism from crypto stakeholders over its regulatory approach in the crypto sector. Industry players, including Alderoty, have accused the SEC of preferring enforcement instead of clarifying rules. Aside from crypto enthusiasts, Arthur Jacoby, a former SEC attorney, has slammed the SEC for its regulatory approach in the crypto space. Instead of engaging in transparent and public rulemaking with industry comments, the SEC has chosen to mark its digital asset territory via the federal court system, Jacoby noted. In response to this criticism, Gensler has maintained that existing financial market rules are clear. Meanwhile, a decision in the Ripple v. SEC lawsuit is expected to be given in the first half of the year, as both the SEC and Ripple are asking Judge Annalisa Torres to rule in their favor.